for this committee. We thank you for everyone who's given their time. And Lord, we just ask that you please help us to make a difference. In Jesus' name we pray, amen.
Amen. Okay. So, has everybody had a chance to review the minutes from the September 19th meeting? Yeah? So, do we have a motion to accept the minutes as written?
Make a motion.
Okay, do we have a second?
Second.
Okay, so all in favor? Aye. All right. So, we have a couple of representatives and a senator here, and so I'd like to see, would you
Yes,
introduce them, please?
we've been communicating the Blue Ribbon, and by the way, my name is Jeannie Herron. Dr. Kozlowski.
Sorry.
Yeah, that's okay.
I'm on call.
That's okay.
Yeah.
We had a meeting several weeks ago, probably a month ago, that 3 representatives attended, and these 3, Senator Bryce Wiggins, Representative Jay McKnight, and Representative Jim Estrada could not attend. So they were able to come to today's meeting. And so I really wanted to give you some information here, a packet. So Senator Bryce Wiggins, there you go.
Thank you.
And
Jim Estrada.
Jim Estrada, you are
Jamie Allison.
Allison.
That's my sister.
Is that your sister?
Yeah.
Oh,
Okay.
my goodness.
Yeah.
Allison.
Allison, yeah, that works at Youth Court.
Yes.
And Jay McKnight is not here. Okay, well, maybe he will be coming. So thank you so much for coming. As you know, the Board of Supervisors approved the formation of a Blue Ribbon Committee. And I kind of wanted to go through the purpose of our committee. And about a year and a half ago, a little over a year ago, there was, as you know, there are many children in state custody in Harrison County. In the past, there's been many, many, many children. But over the last, I don't know, 6, 7, 8 years, the numbers have gone down significantly. In 2019, I believe that there were like over 800 kids in custody, in state custody. Today, there's around 240. To the general public, that sounds really amazing. That's great that, you know, where the numbers are decreasing significantly. But we that work in the system know that neglect and abuse still is happening.
And it should be noted that the number of reports have actually gone up in that time.
Right. Yes. Go
That's
ahead
in
and
Harrison
introduce
County,
yourself.
not the state, right?
Pardon?
You said state, that's Harrison County, right?
State. Well, yeah, Harrison County, that's only Harrison County.
Only Harrison.
And historically, Harrison County, oh gosh, I've been involved in Harrison County for 15 years maybe, something like that. And historically, Harrison County has always led the state in the most neglect and abuse. So we took note last year, and there was numerous people, including Board of Supervisors Rebecca Powers, that was very concerned because there was a lot of infant deaths last year. I think hey Lauren, how are you? In the span of 3 months, there was, I think, 3 of them that just happened, right in a row. And the last one was called Baby DJ. And I think probably most of you know the significance of that the baby was definitely physically abused. So we got together and decided, this committee, we did a lot of talking, and we wanted to form something to put policies forward and maybe have a system where things did not fall through the cracks for these children. So Dr. Caldwell here, they had a significant role in the Baby DJ for us here, that's who we go by, that's the name that we go by, is Baby DJ, okay? So we can't, divulge the name of the child, but from all information that was given, and I'm gonna turn it over to Dr. Caldwell now, because they had the baby was in the care of Memorial.
So I guess the biggest thing for baby DJ is that he was known to CPS. The hospital had put in 2 separate concerns to CPS about possible abuse and neglect. And from our understanding, they were unable to locate baby DJ and his family, and time lapsed, and the cases were closed without investigation. And then the baby turned up at 4 months to our ER and was pronounced dead. So that's where our concerns came from, that this baby seemed to have fallen through the cracks, that concerns were made, CPS was notified, and they weren't able to find him. And that's where we're kind of coming to you guys with our baby DJ alert, that if they're ever in that situation again, that we can put out that alert and get everybody, social media, the news, everybody looking for this child, to just get this child into a safe environment while they're able to then do their investigation and figure out what's going on.
So with that being said, the Board of Supervisors, we went to the Board of Supervisors and wanted to form a committee on child protection. Not to oversee child protection, but to put forth some policies and procedures that maybe things like this, better communication, that things like this would never happen again. So the Board of Supervisors unanimously, approved the formation of the Blue Ribbon Committee. And the purpose of the committee, it was established by the Harrison County Board of Supervisors by unanimous vote. The committee is established to provide oversight, recommendations, and guidance on matters pertaining to the protection of children in Harrison County, Mississippi. Our objectives is to review and recommend policies and procedures that promote the efficiency and effective governance, to serve as a liaison between the community and local government on issues of child protection, to monitor and evaluate the implementation of policies and initiatives addressing child protection in Harrison County, to ensure transparency, accountability, and public participation in government processes when addressing child protection. And I am quite proud to say that in the year that we have been up and running, let's say that the communication between Child Protection Services and the hospital has improved significantly. Okay?
And the youth court as well.
And youth court as well. So we have made progress. And Dr. Caldwell, you want to go on a couple of issues that the progress has been made?
So initially, we didn't have a phone call, a number to reach a supervisor after hours. So if this was an evening or a weekend, we had no way of getting a hold of a person at CPS. We could put in our online reports, but we couldn't talk to somebody if there was an emergency, and that has all changed since then. Now we have an on-call list, we have phone numbers, we can get in direct contact day or night with somebody from CPS for emergent concerns. We've had a lot of issues with having concerns, I'm from the NICU, having concerns with safety after discharge, and we've been opening up a lot of communications with that. We have daily meetings in the NICU with our social workers, we have weekly meetings with CPS to talk about high-risk cases, and we're working towards getting a lot more communication so that we can feel more comfortable at the time of discharge that all of our concerns have been met. We're starting to get safety plans, which is something we weren't previously privy to. So that's what CPS has determined at the time of discharge if the baby goes home with the family, that there's a safety plan in place. And prior to this, we were never given that safety plan to make sure that each one of our concerns were being addressed. So now we are starting, just now, starting to get those. So we're working with CPS more closely to make sure that all of our concerns are being addressed. We still have work to do, but we've come a long way. And that's just some of the first things that we've done just at the hospital level.
So there has been significant process, but there's always, when progress is made, there's always more improvements to be done. So, we're here to work together with Youth Court, CPS, to hand in hand. Another significant issue that has come up, and Beth Casey is going to kind of go over that, but is this new, it's a state code, and it's code 43-21-301, correct? Some years ago, I think it was 3-4 years ago, this law came into action in the state of Mississippi. It was amended, okay, well, go ahead, go ahead,
You
Deb.
know more.
You know more, go ahead.
So there was as you can see, and I think
You
if
should
you
have it.
received part of the agenda, it has the statute as written now. And one of the things that was added, basically, or added changed, I should say, had to do with removing children from their parents' custody, okay? And so one of the things is, in terms of the definition of neglect under a statute, what defines child neglect so that the court can act, right? And so one of that was that basically they took out that the sole reason could not necessarily just be that a parent was unable to provide food, clothing, or shelter, right? So that was one. And that it was caused primarily by a financial inability of the parent. The only way you necessarily intervene would be if services were offered and the parents or the guardian said, no, we don't want anything, right? We don't want any help. And the other thing was that, and I think that this may have been somewhat of possibly an oversight in other words, to remove marijuana, I think all substances were removed, which meant basically that if a child was born testing positive for any substance, and that included not just marijuana, but also methamphetamine and fentanyl and et cetera. So that was not just a sole reason. Where before, if a child was born testing positive for any substance, and this included marijuana as well, unless and some of this was up to the local youth court could make some definition on that too, right? But so it kind of took that out, whereas before, if a child was born testing positive for any substance, right, that would warrant a report under the mandatory reporting statute to CPS, right? The thing is that that is not the only reason, whereas before, that was the only reason, right? If this child was born testing positive for a substance, reports made, somebody from CPS went out, and that child was possibly removed. More times than not removed, right? Until you could make sure that the home was safe and that kind of thing. Well, when that changed, what that did is children weren't necessarily being afforded the protections that they would otherwise need in order to be safe. For example, a parent and a child testing positive for, let's say, fentanyl. That has substantial, not only are there withdrawals, which are quite severe in some cases for infants, right? But we also have to call into question the ability of the parent to actually provide for the health and safety of the child, right? So what we're hoping to do is and that is a part of your packet, where we would like it to be amended to reflect more that, and it's a finding of probable cause under this subsection shall not be based solely upon a positive drug test of a newborn child or parent, guardian, or custodian for marijuana. So it leaves the marijuana part intact, What it does do is it says this provision applies only to marijuana and not to any other drugs such as methamphetamine, fentanyl, cocaine, or other scheduled controlled substances, right? And so a positive drug screen of a newborn child or a parent, guardian, or custodian to one of these drugs can be the sole basis for the department to take the newborn into protective custody. So it is affording protections for the infant, right? Now, that doesn't mean necessarily that the child has to stay in custody forever. It means until there can be proper investigation and we can ensure the health and safety of the child wherever they choose to place the child, right? I'm watching your face.
So it's not,
When the time is right, I'm happy to discuss how that law came into being, because we were
So you
on-
might have been part of that,
Yes, I was.
as the amendment? Mhm.
Yes.
Yeah, okay. So maybe you could, shed some light on that.
So, you want me to stand, or?
You can do
Yeah,
whatever
absolutely.
you're comfortable with, really.
So just for some background, so I'm Senator Wiggins, and I'm chairman of Judiciary A in the Senate. I also practice in youth court. I was a youth court prosecutor. I handle cases in youth court. I do chancery cases. So, and I've been on the Judiciary Committee since I've been in the Senate. Okay, so in terms of the history of what you're talking about, and the reason I'm familiar with it is because we had a long debate back when it was done. And the reason that those changes were made was because what was presented, well, let me back up. This is really good because this is what we need, because if we're going to amend laws, this is what we need to do, and we like to see, okay, how are things going on the ground? Okay, the reason that got amended back in the day was because throughout the state of Mississippi, children were being taken from parents simply because of marijuana, okay? That's simply because of that. Also, what was presented to us, and there is a whole basis of research that has come to this conclusion, that taking a child from a family member is traumatic in and of itself. And so what was presented to the judiciary committees was, there are places in this state that simply because a person tested positive for marijuana, they were taking them out and placing them in foster care, okay? It was the decision of the committee, it was the decision of the legislature, that sole basis was, when you balance everything out, was not good, okay? And so, so that was done, and that's also, and this was also based on what was presented to us, that throughout the state of Mississippi, what was being done in different youth courts was children were being taken from people solely because they were poor. Okay, this Mississippi legislature, that is said, that is not fair to take a child, when you look at everything that's out there, create trauma within the family unit because a person can't afford it because they're living in a trailer somewhere, just making that up.
Sure.
So that's why the law got changed, and this was presented to the legislature by, I guess at that time it was DHS and all that. So that's why that was presented. And then as far as the drugs, you know, from a standpoint of marijuana, we're now at this point where the state of Mississippi has authorized the medical marijuana program. So at that time, people were, if you're going to actually rank things, marijuana was lower on the scale. You take, I'm not really sure, as I read the law and as I understand the law that was passed, if a parent tests positive for fentanyl, and there's this nexus that they can't take care of the child, then yes, you can take the child into custody. What I'm hearing in my research from this is that the courts or this commission is wanting to take children just because a parent tests positive for fentanyl, okay? you're correct, that what the state has, or the legislature put in there, that there has to be the nexus of, is the child in harm, and they're doing that. That all gets back to the poor aspect of it, okay? So what the legislature was trying to prevent was this, what's the word, random, let's take a child into custody, put them in the youth court, go through foster care because a person tested positive for drugs. And they do that when the person probably needs treatment, they need this, and if it can be done, that they be with the family at this, instead of being taken from the family.
Oh, absolutely.
So that's the background of that, and it's also been my experience that a lot of this is how judges interpret this. So my observation is what I've heard being presented, and when I did my research is, I was a little confused because that's not how I read the statute. So then my question is, why was it being interpreted that way? Because, or what are we trying to accomplish that can't be accomplished under the amended statute that was done? Because when I got the letter from Judge Alfonso and read it, what I was reading was that we want to take the law back to where it was before, which then will create the issues that we had before.
Right, now,
And we don't want to do that.
right.
So if there's
I
something
think
that
we
we can.
agree with you on that.
We-
Okay, all right, that's
Right.
good.
Yeah.
Which is why
Yeah.
I guess the proposal would be,
Just for the marijuana.
For the marijuana.
to exclude the marijuana would be kind of.
But what is, I guess, to me, Harrison County is the only one bringing this, like, I haven't heard this as an issue in Jackson County, which by the way has a lot of cases too, led to that particular part of it.
Sure, and that's, yes, because it's our understanding in Jackson County, and like, as you mentioned, judges really kind of interpret how this is gonna roll, so I,
Which is gonna lead me to talk about some other stuff, but yes.
right. So what and this is, and, I suppose we could get into a discussion about this, but I think an unintended consequence of the way that was amended is we were looking more for reasons not to look into the health and safety, number one, of a child. All of this coming out of the situation involving baby DJ, right? So when we look at it from a prevention standpoint, had the point of intervention been when the child was born testing positive at that point, quite possibly these other events that occurred would have been prevented. One of the reasons that were given, and again, this goes to assessing and determining the health and safety of the child, right? So that would require an investigation, right, by CPS, which they are the agency mandated by law to investigate allegations of abuse and neglect, correct? So what happened, though, is in this situation, it was, we're not able to locate them. And so what does that, how do we define that? What's defined as not able to locate, right? Versus had the child that was born testing positive for fentanyl been removed at the point of, I guess, contact, which would be the NIC unit, that quite possibly.
Yeah, so we don't
Sometimes,
know that
but
stuff
not
right
always.
off, yeah, we don't always know that at the time of discharge.
Correct, right.
So
So that brought up a whole nother, so the issue here is not to necessarily go around taking poor folk children. That is not the issue. The issue, so I think that quite possibly the way that it was written and amended is that it's being interpreted quite possibly in a totally different way, is the point. Does that make sense?
And I
So
guess-
what we're hoping to do is to be able to look at, if you have an infant that is born testing positive for fentanyl, or even, let's say cocaine, for example, if you look at how long that takes for the drug to leave the system, most all of them leave within relatively 72 hours, whereas marijuana stays around a good minute.
So your concern is about the investigation that has to be done on that?
The investigation, yes, and the intervention. In other words, saying, CPS, you can remove this child, not, you gotta leave this child
Because we haven't fulfilled the.
because
second
we
part.
haven't,
There's no other.
because there's no other nexus,
Yeah. So
there's
if you-
nothing else on the,
So if you take like a newborn in the NICU, the parent hasn't had the child to show the second nexus. Like they've never taken the child home, so it's almost like we have to send them home and have something happen to the child before we can do something. And we're feeling like we can't try to prevent in higher risk situations. From something bad happening before it happens.
Yeah, I see. My question would be, and it sounds like, so if a child is born with fentanyl, so why isn't an investigation being started right at that time?
So we put in for an investigation to start, and it almost always ends in can go home with family, but it's
From
not
CPS
from CPS.
or the youth court?
Yes,
Because there
without
isn't another,
necessarily,
there isn't
because
another.
there isn't another part to it, they've just been positive. So I feel like we're not getting those families the services that they need to get clean, to stay clean, to make sure that they've got the supports that they need so that, we're not turning back to drugs in 1 month from now when, everything gets too tough. That's the stuff that we're worried about.
I guess I'm having a hard time just because it would seem to me like an investigation should be done. If you got fentanyl on that, and why CPS, if they're doing that, what that means. I will say this, I don't know much other than just kind of what I looked into on Baby DJ, but I can say this, that there was a lot of factors involved, not just, and if I'm looking at it, there were issues along the whole the whole way. It's not just one party, but also a lot of them were the parents. And the parents were an issue, from what I heard about Baby DJ's case.
right.
So with all that, yes, it does seem like CPS, assuming that's them, needs to make an investigation. It just goes back to why isn't an investigation being done when a baby, that should ought to be automatic, whether it's Jackson County,
So yes,
Harrison
the
County, or
investigation,
DeSoto
we
County.
are putting in the report, an investigation is
Okay.
being done. But because there's not a second nexus, they are always closed.
So it's
Because
because
there's
no
never-
harm has been
There's
done.
never been an
And
investigation.
a lot of opinions, the harm is the
So-
illicit substance that they're positive for. I mean, that is harmful.
So the question is, okay, they may test positive for fentanyl, but there's no harm to the child otherwise?
Well, the child's just been born and has now been in the hospital the whole time, and
There's no
so
other opportunity.
there hasn't been an opportunity for something bad to happen yet.
But it is harmful. I mean,
There hasn't been. Oh, I see, okay.
See, so when you put it on the.
So they're saying that the drugs lead to the harm, but you're saying hadn't been an opportunity.
So we're saying that the drugs lead to harm, but they're saying there's not been an opportunity to the family to neglect this child or abuse this child yet, so they can go home to potentially receive this, and then maybe we'll take the child away.
and Jackson County has been at several meetings. They've been involved. They are working on some of their own stuff, but they have a lot of the same concerns that we do. And they've been looking at creating a committee like we have.
Well, they haven't
Like
talked
we
to me
have.
about it, and I've been in the courtroom last week, so maybe, I mean,
don't
And I
where
know
they sit
Judge
with it.
Zorn-
They haven't been in a couple of months, but they have
Singing
been
River.
here. Yeah,
Is it Singing
they have
River?
been
Singing
here
River?
a good bit.
Sure, and I think part of this also came out of providers who were providing health care to these.
what has CPS said the reason to this question? Like, why aren't in it, if a baby's born with fentanyl, why are they saying that's the,
Because there has to be another,
Resolution.
there has to be
They're
another
saying that
nexus.
there has to be something.
There has to
Say
be
no
something
findings.
else. There has to be another issue. There has to be something else.
They
Like I
say
said,
there's no
based on
findings
this
to
amendment.
remove.
I think
well,
that was
again,
an
that goes to
unintended
interpretation.
consequence.
Right, exactly.
Yeah, okay, that's why we have a legislature.
So we have one of our hospital social workers here.
So I'm Melissa, I'm the manager of care coordination for Memorial, and we work very closely with the NICU and with CPS, and we have the weekly meetings, so I can kind of speak on what's going on there as these babies are born and they're positive, and we file the CPS report and we go through the motions. But then when we get on these calls and where we can actually interact and say, well, kind of what is going on here? What are you doing? They say, well, the mom was positive, but, we're investigating the home, and then it turns into, well, we're gonna send the baby home on a safety plan, and we'll follow up once the baby is home. Now, once the baby leaves, we have no way to know, is it being done, is it not being done? What kind of services are they being offered? What kind of follow through do we see with
But
the
is that
parents?
not CPS's job to
It
do
is
that?
CPS's
Okay.
job, but the problem is, more than once, we have seen safety plans that were proposed and then questioned, and at the absolute last minute, CPS ended up having to take custody because their proposed plan didn't come to fruition, but had we not pressed, it would have been a very different situation. So it's the not having the second nexus, that we've got the positive drug, we can't prove that any harm is physically being done or that the child has been neglected because there's not been the opportunity for this post-acute situation to happen, and we discharge with known positive, a lot of times more than one family member, and not knowing if the care that this baby is going to receive is going to happen. And yes, it is CPS's job to do that.
So let me ask a question here. So if a parent, and the baby is born with, whatever other than marijuana, isn't it neglectful if the parent continues with the drug, testing positive? How could they provide safe care for a child?
It's a very good question.
That's
Well,
Well, that's the problem. How many
That-
people do you know that do cocaine and fentanyl that can safely provide for a newborn? It's just, it's
Well-
kind of an
It's
oxymoron.
it's a technicality issue. is what
Well,
we're running
believe me,
into.
I'm not defending any of that. I prosecuted for 10 years, okay? So, but that was the problem that came to our attention when this was, I'm gonna use the word assumptions. You're on marijuana and therefore you automatically cannot absolutely take care of a child. We got alcoholics at home, okay? But we don't go and take children in. I mean, I know plenty of alcoholics, well, I have, and the kids could be suffering, and we as the courts don't go and take them away. So the whole point was, why is it marijuana, why is it that? That's the whole, why are we not doing that with alcohol? So that was the point of where we got there. So the assumption that, I think that's part of the crux of this, is assuming, and I'm not saying, I would tend to agree with you. The issue is how it gets handled in the courts throughout the state.
Correct.
And people are assuming, well, just because you tested for marijuana, therefore you cannot take care of your child.
We're not
Right.
saying, we're not saying with
We're not-
marijuana.
No, I'm sorry,
Yeah.
fentanyl. I mean, I'm
But
gonna use,
fentanyl,
no, I understand that. Believe me, I'm
Yeah.
not denying that.
Right.
And I think it becomes a matter of that. But that's a policy decision, that if we wanna say fentanyl and meth and all that, that you automatically, it's assumed that you cannot take care of them, then we need to change the law on that. I mean, that's the point, and that's what I hear y'all saying, I guess.
yeah, we don't have any problem with marijuana keeping that, but it's just to clarify the other hard drugs that, we all know that if somebody is on methamphetamine, I've seen it. How can you possibly take care of a baby or children when you're high on methamphetamine? We're not saying marijuana. That's already been, but I think the interpretation of each youth court or court is not, they include every other drug in with the marijuana. That's what is happening.
Well, and let me talk about that. That's what I wanted to bring up, because I think this goes to that. There are, under my committee, last year we did judicial redistricting. I was in charge of that. Part of all this was discussing a statewide youth court system, okay? The fact of the matter is that, as has been stated in hearings in Jackson, that there are 82 different youth courts in this state. They give 82 different senses of justice. So what Harrison County thinks is justice, Itawamba County doesn't think is
Right.
justice or whatever. So what we have been trying to do, based on recommendations years ago from the Supreme Court, was to come up with a uniform youth court system. Only every time it comes up in the legislature, individual youth court people and personnel fight it. Because they don't like their cheese being moved. That's me paraphrasing, okay? And in the meantime, we got children who are being doled out. The justice in DeSoto County is different from the justice in Jackson County, and that's a problem.
Mhm.
Okay, I saw on your agenda, you have my kids, okay?
Right.
Which I'm glad to see, and that was in the letter. So 2 years ago, Chairman Hood, my counterpart in the House, and I worked on a bill. It was he came up with it, to do an audit of my kids, okay? That audit came back. We're actually having a hearing on that next week. What that revealed was how terrible my kids is. How terrible it is, unbelievably how bad it is. And their recommendation is for, and this may sound like a lot of money, but actually in the state, it's not. For $8 million, we can do a new system that will do everything that you should probably do
Great.
and would help in some of these things. Because part of the audit that they found was that nobody's talking to each other, that my kids this is what was told to us, it's 35 years old. Like, we're way past that. And so it's gonna be my goal, and I think the chairman there, to get a new My Kids system so that these type of things don't happen and everybody can talk to each other.
Right.
And that's one aspect. But the other aspect is the confidentiality that shrouds the youth court system. We had a youth court task force that was done 2 years ago. We had hearings on it. Came out, the number one thing that came out from the task force was the referee system within the state of Mississippi is terrible, okay? Now, that doesn't apply to Jackson County and Harrison County and DeSoto County, so there's about maybe 15 counties, but all the rest of the counties have a referee system. Well, we tried to do that and they fought that. Like, I could go into details about that. So during the judicial redistricting, we had a lot of conversations about that. But I can say this, that the legislature and certainly the Senate is committed to getting a better system. Then to finish on that, this hearing that Judiciary Aid Committee is having next week. We're hearing from they're called CSG. They're like they oversee a lot of, not oversee, but they're part of legislatures nationwide, and they're a research arm and all that. They came to us and people to us, and they said, your series of laws are terrible. In fact, they said Mississippi's one of the worst in the country. And I said, really? And they said, yes. And there's reasons for why they said that. And I could get into that. And so when I look at it, when Bryce Wiggins looks at this, Senator Wiggins looks at this, this is putting a Band-Aid. What y'all are doing, which is, we need it, but it's putting a Band-Aid on the systemic problems that baby DJ was a victim of, that y'all are trying to address.
Right.
And I've said this, I've said it in public hearings, I've said it on the Senate floor. The legislature has failed to stay on top of this. And part of this has been because of the reluctance of youth courts in this state to participate. Now, I know Judge Favre in Hancock County. I know Judge Dickinson here. I know Judge here. I was actually emailing with Judge Favre. He's been very good. Hancock, when I first got into this business, Hancock was terrible. To their credit, and we put a county county court system in there, and
Right.
it's gone much better.
Right,
We can make these things happen, but when I wanna do this, and this thing isn't gonna be solved overnight. And we can do these things, but these are Band-Aids, when I look at it, these are Band-Aids into what is affecting the system, and in my opinion, what I've learned happened with Baby DJ, the system failed that child. And trying to it's been a chore. Well, let me say this. It's been a challenge to get people in this state to understand that, particularly stakeholders. However, I think we're getting there. And with the judicial redistricting that's occurred, there's a new youth court association, if you will. CPS used to be under DHS.
right.
The legislature pulled them out because they literally were being overlooked by the legislature within the big bureaucratic agency of DHS. Well then, and I think this is pretty clear, the appointments that came over the agency head weren't what we needed at the time, okay? So CPS has struggled to get there, and I personally have had hearings and stuff like that. So I know that, so my point of all of that is certainly my committee, the Judiciary Aid Committee, and we are looking at this, and we're doing that as early as next week. We've been doing it. We're gonna hear about the My Kids audit. I think that is something that is low-hanging fruit that needs to be done, that from what I'm told, it could be start phasing in, and we could start seeing changes. Now that's convincing my colleagues that we need to pay for it, which I think they will, there's a commitment. But these things aren't gonna change overnight, and I personally would like us to look at a big picture. We need the Band-Aids, but the Band-Aids are only gonna get us so far under the system that we have, and that's a problem.
I think we all agree.
But
with
I think with what y'all are doing is awesome because it helps with what we are doing and what we're trying to do up there. And Representative Belcher's been on this. I've worked with him. He's been in the House. So I think it can all dovetail into the proper stuff.
Did you say?
I think we all agree with that, and we definitely know that there's a bigger need for a lot of change. But the goal of the amendments and the smaller things that we're asking for is trying to get the Band-Aids done now, to try to do some other protection options, and then move on the bigger things that are gonna take longer, because we know it's gonna take a lot longer. But hopefully this will start a lot more.
And it's really just clarifying, so all the youth courts or whoever, referees are all on the same page, that there's no room for interpretation. That's what we're saying.
Well,
that
that's the problem,
that's what
if
he's
I may
saying.
be, because and the reason
That's what
I'm willing to talk about it is because we're gonna hear it in my hearing, in my committee's hearing. The system with which Mississippi operates on this creates this differences of interpretation.
Okay,
And that's the problem.
right.
The law is, and I'm not here to say I have an answer right this time, but if you don't identify what the problems are, you can't solve it.
Right.
Sure.
And so the system under
I
which
gotcha.
we operate, and this is coming from an outside expert who's looked at our laws and said, this
Gotcha.
creates the problem that you're seeing, that y'all are talking about.
Well,
And what can we do, and that becomes the question.
Sure.
So, and just to not spend too much time on it, but from what I've been told, every other state has some version of, they don't have a youth court system like we have, where the judge in particular and the referee are so involved. Okay, the agency, to your point, the agency's the one who does all this, which also means they're the ones who have the responsibility should things go wrong.
Sure.
The
Absolutely.
problem of our system is it's so wide and varied, and we have this crazy system of referees and permanent youth court judges like we have down here. We gotta work on it. But the system creates that.
Right, and there's not been uniformity, I worked at the youth court.
Okay, so
I know
I'm telling
exactly
you
what
stuff, that's right.
I know exactly what you're talking about, in terms of uniformity throughout. I think that part of the problem too has been some of these counties don't wanna, it's got to do with, money.
Correct. That's right, and
each of
that's-
these smaller counties saying, do we have the funding for, and I think also it has to do with population, if I'm not mistaken, which is how Hancock County was actually able to create a whole nother position, is that not correct?
Yeah, so the short version of that is that under the current law, that when your population reaches a certain amount, you can create a county court.
Correct.
Which everybody, generally speaking, everybody has said that that system works well for a youth court. That's what Jackson County is, it's a youth court.
Right.
So that's why the Supreme Court and everybody has said we wanted a statewide county court system.
Right.
And I actually, the Senate came out with a plan where we would basically create that statewide in those rural counties, let's call it.
Right.
For example, and I'm just making an example, but like George and Greene County, George, Greene, Perry, one other, would be one county system,
Mhm.
and you would operate the youth court through that.
Right.
And you're right, they don't wanna pay for it.
Right.
Okay, yet our children
Right.
are suffering
Right.
by a system that is there.
Right.
And so the reason Hancock County, I think their population got enough, they were able to create a county court and use Judge Favre and that, and they were able to do that, which has been great. Which
Sure.
to me is proof that the county court system works
Oh,
as,
absolutely.
in terms of a youth court.
I think so, too. And that is exactly what is the most effective. So,
I'm gonna
but,
bring you to testify.
but I think what we're looking, and I know, as you do, is that things like you mentioned, it's been how many, 30-something years? So these things have, yeah, so
Right.
what we were looking at is what can be done now
Right.
in terms of the amendment until systematically these things can be addressed.
Right.
Because, as you know, if we wait for the systems to be.
Oh, yeah.
We may not, I certainly may not even be here for that, you know, myself. So I'm just saying. There's something that you also said, and I think that this is a very interesting point because I think it's been used, and in some cases, more generalized versus specific, which has to do with the trauma a child endures from removal, right?
Yes.
And that is a question I think that both looking at trauma, childhood trauma, how we go about preventing that, to say that if a child is enduring parents who are unable to provide for their safety, unable to provide for their care, and their family system is not functioning themselves, that, and the trauma that a child may be experiencing in them, because we know childhood trauma occurs within families, within those family systems, right? So to say that removing them from that creates trauma is I think, in some respects, maybe an overgeneralization, I suppose. If I can, and I know that that's a philosophical thing, I really do.
Well, no, it's actually a scientific thing. It's been proven that that's the case. Yeah, it has. The problem is what you're saying, which is, so you got a family that's creating trauma, because that's where the child is.
Traumatized, correct.
So is a child being in foster care, is that better than being with family members? And let me say this, the law as it is structured right now actually says the number one result is to be with family.
Absolutely.
Absolutely.
Yet throughout the state, the automatic result ends up being placing them in foster care.
Right.
which is traumatic in and of itself.
Right, and I'll agree,
And-
and let me just, I don't mean to cut you off, but I'm a clinical social worker. I do treatment, I provide therapeutic treatment for traumatized children. So I guess what I'm getting at is, while I agree that certainly we don't want to do anything more to create anything more for a child. And we do know, you're absolutely correct, there's a lot of research into this that goes both ways. The foster care system in and of itself has been wrought with problems. We all know that as well, you know. And children are best served in their family of origin when the family can function.
Right.
Right?
Yes.
So I think that's, and in the treatment of children that have been traumatized, one of the hallmarks is that that child be safe.
Right.
In order for you to intervene therapeutically, right? So, which means if a child is being re-traumatized, you know, you doing
Well,
treatment
it
of that
becomes,
is
it
not.
becomes the question, what about being in foster care or being there? And
Absolutely.
And we do not, I'll say, it, we as a state don't have all the resources that we need.
No, we
Okay.
do not.
So it's a, what is it? Is that called a Hobson's choice or something? What do? Put them in foster care?
Sure,
and then
it's a,
put
it's
them
a
back
real
in the
catch
family?
22.
It's a catch
Honestly, it
22.
really is, and it
Right.
does go.
And
I-
it's not easy. And
No.
so from a legislative standpoint, that's what was being presented to us, and you're trying to, I believe the first to admit, the words you put on a paper, that's why we have laws and lawyers and all that, and that's why we have the legislature, so we can come back and tweak things and refine those things to get what we need to get.
Right, which is really kind of what
What
we're
we're trying to do
What
is
we're
just
trying to
tweak
do
it.
is just
Right.
say, hey, was this the intent of the legislature, or, you know,
Yes,
because,
to make all
to make
drugs
all
equal to
drug- you
marijuana, or can we have a distinction between marijuana and the rest of the drugs?
Oh, no, the intent was marijuana had a distinction away from everything.
Right.
Right, and now,
but that's not,
it's
How
got
it's
a
being
distinction and
interpreted.
everything's coming over with it, it's pulling everything with it. It's
Yeah,
like-
it
it's
sounds
what we're
to
seeing
me
in
like-
practice.
And I've seen this in my practice, and the agency, which is CPS, makes, whoever the lawyer, whatever, they make a rule, oh, this is what it says. Because I personally, in my role as center, I've said, that's not what it says, because I've drafted the bill, and the agency, be it the Department of Education or whatever, is saying, this is what it says. And then we go and we fight about it, and then we go and pass another bill to clarify that.
right.
But the problem comes in and the agencies look at it and go, this is what it says. And then that's not what we intended, but that's also, we got three branches of government, and that's what we did.
Exactly,
Yeah, and so we
exactly.
asked for that interpretation, and
Yeah.
we
Did you?
declined.
It was declined?
We were declined because
Yeah.
we weren't, how do they phrase it, that we
Uh,
weren't,
need to know, basically,
or that,
From who?
that our group wasn't,
From the age.
a body that was
yeah,
allowed.
that was, allowed to ask for that. So then
Yes.
Judge Alfonso put it back through herself, and we haven't gotten a response yet.
I'm gonna see what I can do. I'll see what I can do.
Right.
Yeah, that came from the AG's office,
Yes,
because we
that did.
wanted to get. what was
But we wanted
clarification.
clarification, and, you know, because we all know sitting here that the intention was the marijuana.
Yeah.
But it's not
And we
being,
agree with that.
but yeah, we agree with
Okay.
that. But it's not being interpreted that way. It's including all of the other, you know, substances, fentanyl, methamphetamine, cocaine, you know, whatever it is, okay? So we all know sitting here in this room that, you know, that's unacceptable.
So can I ask you a question? So if, which, as you're saying, let's say the baby tests positive for fentanyl, okay? And then it is such that, okay, they test positive, we can take the child into custody. Then what is this commission said should be done at that point to, I guess, keep harm from happening?
Well, and it's great that you kind of asked that. It's, so if you look at, it's basically, and you mentioned confidentiality, all these issues become so complicated by so many other factors. But one of the things was to be able to collaborate with those that have made the report to say, okay, how are we going to implement whatever intervention that is that we're going to, and then there's a sharing of information.
I am so hoping this my kid's audit, and I am happy to, gosh, you know what, I actually have a copy in my car, because it's gonna be public,
Mhm.
we'll fix that. Like, I'm told it will fix that.
But
You
who's
know,
able to get that information?
all the stakeholders here that you're talking about, CPS, Youth Court, DHS, it's all one system that goes, right now, my kids is walled off,
Right,
which is a problem in all this. The system that has confidentiality and other things built into it, what happened was we directed the administrative office, the legislature directed the administrative office of courts to do an RFP for an audit. They did an audit, they did that came back actually in like August,
mhm,
okay? I don't know what the cost was, and they came back and did an analysis, and they said, here's what it is and the cost, and they detailed that these are the people who would be involved, that the information would be sharing, all the various stakeholders because I agree, like, that is what is supposed to happen,
mhm,
because when you get all these people involved, you need that team aspect.
absolutely.
Which is why you had the multidisciplinary teams kind of originally.
Before.
The problem,
Correct.
and
You
this
don't
is a
have-
systemic problem, why I guess I'm hitting on this may be one low-hanging fruit that actually could be done fairly quickly. The problem is the computer system is only youth court, and all these other agencies and all who, as y'all know,
Mhm.
there's AG's office, CPS, DHS, sheriff's office, youth court, who are all involved, and none of those people can access
Chancery
money.
Court.
Right,
Yeah.
which is part of the problem too with Chancery Court, especially ironically
Correct.
enough, where chancellors actually are the ones who are overseeing youth court cases in counties
Yes.
that don't have one.
So, back to your question, yes, it is my hope, and I have a little more understanding now, that this computer system will actually do that. Will let everybody share information.
Right,
Maybe Harrison County could be the pilot
Well,
We
program.
that
would
would
love
be-
that, we would love
Okay.
that,
See,
absolutely, we
that's,
would love it, we would
Okay,
love
there you
it.
go, all right.
that's somehow when we can.
I'm writing that down.
Yeah, please do.
Well, there you go. There you go.
We would
That
love
would be
it.
great, because, and I think it really all boils down to wanting to do the best we can for the children, and honestly, subsequently, their families.
Right.
Ultimately, that's what you want, and,
Yeah.
and to have interventions that actually are effective, and things that, for example, especially where substance use is a problem, which oftentimes is also, you have co-occurring disorders, correct?
Yeah.
And so being able to go and maybe provide care that address all of that, versus being very black and white. And I think that what happens sometimes is when things get put in, it's like, okay, nope, we don't do that anymore. We don't take kids that are, positive
your-
or whatever.
I'm sorry, to your
That's right.
point, that is ideally what we want. And Harrison County, with as many, believe it or not, has many more resources
Than
than
anywhere else.
others. And so when we're looking at, from passing a law statewide, then these other counties that don't have that, then they go, well, we can't do that. We can't provide them resources, and we can't do that. That's why we get into the situation that we do. That's why we're looking at the statewide. See, the state has said, we're willing to put money and resources in it, but I personally have said to different ones, as has the legislature, we've got to change our system before the state puts all this, because we can't keep funding a system that's not working.
Right.
We got Band-Aid, I get that.
Right,
but we
right.
gotta do that. So my point is, yes, ideally, every county in the state would do what Harrison County does in doing that with the resources that it has. And the state we are trying to do that. It's just, that's why we're looking at the computer system, to do what you're talking about, where we have everybody involved with this child,
Mhm.
whoever it is, so that they're not going back to a home that's bad, or the parents aren't relapsing and all this other kind of stuff.
Correct, and where you end up with, if you look at the long-term impacts of that on your communities, your neighborhoods, your communities, overall society, really.
Right.
You have the lack of productivity. You can look at any of this from all different perspectives, really. But
Well, in terms of the actual, when I looked at what Judge Alfonso said, from an actual standpoint of passing, or at least from drafting a bill and passing a law, I saw Richard Bennett said he was gonna do something, so we can work together.
That would be great.
We can work together on that.
That would be so helpful.
Now, people ask me, can you guarantee that it'll pass? I'm like,
No, we
That's
never.
it. Well, you know, and it's so simple.
So we can try, I
Right.
guarantee you we can try.
Right, because it's so
Right.
simple, because it's just tweaking a couple of little words in, you know, in the,
Jim's been up there for two sessions, and he could tell you the simplest things become the
And-
most difficult.
But the good thing is, we have, I'm on the Jet A in the House.
Okay,
The good thing is we've got, you know, good relationship.
Good.
With Senator
Well-
Wiggins and with Chairman Hood.
excellent.
So I think, you know, there's gonna be some good movement.
Right, we're not asking for the whole bill to change. You know, we're asking for just a few little tweaking,
But
amendment, just to
I'm
amend it, just
I'm
amend it.
asking for y'all to help us
Sure.
change the system.
Okay,
Well, you tell
That's
us
fair
how,
enough,
you
fair
tell
enough.
us how we
It's
can
the-
help you.
so
Well,
maybe
this is
broaden
starting.
that,
Huh?
maybe broaden the scope
Yeah.
of things to,
Well-
and I think bring I do think attention, I think that people need to, and I'm talking about our Mississippians.
Yes.
To have a real clear understanding of what the system is that we currently have, where it is, and also tying in, and one thing we didn't really touch on, but to look at the juvenile justice in and of itself. So these are all the same, but what I'm getting at,
You
and
need
I
to
can
come to
tell
our
you, somebody
hearing
that
next
has
week.
worked, well, I have worked in all three, as you can see, I have had I'm long in the tooth. And I've worked in all three of the different systems. They are all the same people. They're not, so it's like, okay, how can we begin to address that? And if a youth court system everywhere in all the counties. And I like the idea too, because I know the smaller counties. I was a regional supervisor when there were, I think, 9 counties
Okay,
that at DHS, we had
Mhm.
the 9 southern counties.
right.
And then that began to break down, right, because we saw that, okay, we need to get more narrow, it was too big,
And
right?
that's true.
And the diversity among
Yes.
even culturally, there's a lot of diversity within Mississippi in and of itself, you know.
That's true.
So trying to find something that we can,
And that's why, I'm sorry to keep pushing.
No, that's
but
okay.
That's why the statewide uniform county court system would,
help with that.
I think would solve that. And I'm not the only, like, the Children's Justice Commission from the Supreme Court, that's what they recommended.
Mhm.
And that's what others have recommended. As tends to be the case, you put it out there and then people start complaining about the cost and other stuff.
Mhm.
But, you know, I think I think some of those could be easily fixed by that.
Mhm.
It's just.
Well, the combining of counties that are
Yes.
smaller, your more rural counties, and them agreeing to,
Right,
okay, this, which would be, I guess you would take the same chancellor, using the same chancellor.
yeah,
system, I
and
think.
since we're talking about it, I mean, the Governor Reeves, so that was 2 years, came out during this judicial redistricting and put in to appoint additional chancellors, because you know, under the Mississippi Constitution, they serve as youth court.
Right,
And so his plan was to put additional chancellors statewide to serve as youth court. And so we have been looking at that in the legislature, like combining with what we've done. And that may be something in these places. That, I mean, all this discussion honestly is really good because it hadn't been here since I've been in the legislature.
Mhm.
So it's not gonna be solved overnight, but
Of
I
course.
think
of course.
with what y'all are doing and what we're trying to do, I think
Maybe
we can get there.
together.
And not have another baby
DJ.
DJ.
Right,
Well,
that's what we're trying to do.
Yeah, that's what we're trying to prevent, and, you know, anything that we can do to help you, you know, just call upon us. You know, we're here, and, you know, we all want the same thing.
Right.
You know, we all want the same thing, which is the protection of children.
Well, I didn't mean to take,
No,
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 no, no,
no,
no, you're
thank you.
good.
Thank you so much.
That's
because
why we
it's
wanted
very
you-
helpful
right.
knowing, you know,
What's happening?
the amendment actually came after I left Newport. So that must be
Oh.
after, and I left in 2015. So
that
this
sounds, I
was-
think it was like 2019 or something like
Correct,
that.
yeah, right, that's what.
And to be honest, that was about the time CPS got split out. There was actually a lot of pressure on the state, and all that stuff. Of course, I always talk about the Olivia White lawsuit.
Right,
that we
Olivia
have.
White. It's
So,
been going on for 20
In my
20
opinion,
years.
it's probably the right time that all this stuff for us to look at these laws and do that.
And within the context too of Olivia White, because I do
Yes.
believe that that was some of the things that were
Yes.
part of this, was it not to create a youth court? Some
Yes.
uniformity within the youth court was part of it.
The whole point, yes, to get us hopefully out from under
Right.
Olivia White. And look, y'all, our tax dollars are, I can't tell you how many
Penalties
millions
every
of
year.
dollars a year we end
We're
up
paying
paying.
in penalties and to
Correct.
law firms that are outside of
Yeah.
the state of
Right.
Mississippi. Yes,
We are
So Governor Reeves, I
Right.
know his office and him, Lieutenant Governor Hoseman has said it, I think Speaker White, we all don't want that to continue. We want to fix
God.
that, so we're no longer having
Right.
to deal
Right.
with that.
and I suppose what we don't want to see happen, and just to add this real quick, is that you end up doing that by saying, these are all the reasons not to remove children.
Yeah.
So
and I-
that we reduce numbers, because in some respects, it's an artificial reduction.
Right.
So that's kind of what,
Where we're
I guess, what we're saying too. Is I get wanting to get out from underneath Olivia White. State should have done that years ago.
And
But,
while we're talking about that, if we remove children, then that means they're going in the foster care system. Well, we had a foster care task force 3 years ago that issued a report. And let me say, there were good things, but there were a lot of bad things in the foster care system.
oh, absolutely.
So if you're taking kids and placing them in foster care, there's other issues there. And, you know, and some of that led to changes that we're now seeing in that. There was a write-up about it, but that led to some of the things that we have done within the system, which have been working, such as attorneys for parent representation and stuff.
Right.
So, but we need to get better in that area.
Yeah, well, and it's also how that all is written too. So you can't access, like parents or grandparents were having to get licensed
Right.
as
Oh,
foster parents. But in order to, you know,
You wanna be
To me-
CPS director under next?
no.
Ms. Sanders can keep that position.
We would love it if she would come. We've actually sent questions and kind of had sent invitations. We would love to have involvement from, and, you know, again, we're not trying to be adversarial to anybody.
Pointing fingers, we wanna work together.
All we wanna
understand
do
that's
is
the only
say-
way.
Hey, this is what's going on. I don't think the legislative, I think that there's some unintended consequences. And if we can address those, because I do believe that there are all these other system problems. I mean, they are. But I think collectively, if you get all the community stakeholders to begin to address that, but they have to have all the information about it too,
Yes.
you know?
Correct.
So yeah.
Well, thank you very much.
Thank you.
Thank you so much. Thank you so much.
Okay, so, to move on, and thank you so much. That's been incredibly
This has
helpful.
been very helpful, very helpful.
Okay, so, moving on to the letter.
Right. So everybody has the email that I sent to,
Yes.
okay, so we don't need to really go into that. It's included in your packet there. And then the Memorial Hospital report.
Melissa's here.
Oh, okay, excellent.
Let me set third.
Oh, there she is.
Do you have a copy for me so I can put it in our binder here?
I do already.
Okay, great.
Okay, so in September, we had 18 cases that we reported.
How many cases?
18.
18 for September?
18 for
Okay.
September, puts us at 141 for the year.
Under 41 CPS reports?
For the year. And I just did a little bit of averaging. So if you take the past,
So you guys are on the way out?
yeah, the past 5 years, our average is 187.5 a year. If I projected this out correctly, it'll put us right around 185. About that average, but of course, you know, that's
Right.
some give and take there. But yeah, 18 so far, or 18 for September and 141 so far for the year.
Thank you.
You're welcome.
Okay, so that moves us on to, are there any new report concerns that have arisen or things that we might have been in a couple of weeks? Oh, okay. Hopefully you get on a great
Vacation
vacation.
and then 6.
Oh, Dr. Caldwell, anything?
No, I don't think so.
There's a few.
Okay, thank you.
All right, so, does anyone else have any questions, concerns, if you'd like to say
Did
anything?
you have something earlier?
Yeah, I felt like you all had gotten away from your exemplar case. You were trying to say, hey, I'm asking for a checkpoint beyond the in vitro abuse. You were asking for a checkpoint, which to me sounded like something that was really doable. Because, I mean, had someone just simply said, okay, I'm gonna allow a sober family member to be in charge of getting you to and from a place so that we can check in with the family, then, you know, there wouldn't have been this baby is missing and we can't locate him until he's deceased.
Correct.
So, I mean, Senator Wiggins gave a lot of valuable information. It was a good, robust discussion, but I think we kind of got away from your initial question about, hey, what else, what is a solution for this piece right here, which would have been a simple checkpoint inserted into there.
And the baby DJ law to the alert.
Correct.
Well, if there was a tweaking of that initial law, I think that would have prevented some of the things also from the baby DJ, you know, because,
I guess the problem with the DJ law, what she's saying is that they couldn't do an investigation.
right,
They couldn't find them, so they couldn't do an investigation, and that was,
that's unacceptable.
yeah.
That's unacceptable. I agree. We all agree. Yes, exactly.
So we didn't even have a chance to.
Tens,
Didn't
right.
have a chance to get to that one, we were still on this page,
Yeah, just trying to get a hold of them.
trying to, yeah, so.
Well, I do understand that, but that was the initial question that you asked Senator Wiggins, and I think we kind of got, you know,
Away on some of the
down
other points, yeah.
Right.
Yeah, because we
so, I
did
mean,
email them about more than one thing.
Right, but I think what you're asking is a very doable thing, you know, for something like that, that a baby comes to the NICU and is positive for a very abusive substance. I mean, because to say, okay, that the baby is not in harm's way, absolutely is, because of all the reasons that you just said.
Exactly.
You know, there's a fallout from that on the baby's ability to learn, the baby's ability to be able to take care of themselves as an adult. What happens when they're older? Then you're involved in the criminal justice system. It's going on and on and on. So to say that in vitro abuse is not enough abuse is
It's ludicrous.
correct.
I agree.
That's one thing, and then if you would have just simply had a checkpoint where, when they said, okay, well, we're gonna do the investigation, but you don't send a baby home with drug-addicted parents with no one
Right,
to,
right.
like a sober family member
Right.
to say, hey, we need to be able to have you sign the parent and the kid out, and can we check in with you and you be the responsible person until we get to this place where we feel that this baby is safe.
Safe, right. We're hoping to get to that point, and exactly what you're saying, if that would have happened, if all the systems worked together, all the agencies, and we were able to communicate, and CPS didn't close the case because they couldn't find the child, which I find just unacceptable, baby DJ would still be here. And, yeah, we all agree with that, so.
Well, and I think
Thank
the term
you.
he was using when he was saying Band-Aids, I think you're not using Band-Aids, you're trying to find checkpoints.
Right.
We're starting with
Small
small
checkpoints.
changes.
Right.
Small
changes.
things.
Yeah, because who knows how long it's gonna take, like
Correct.
Beth
Yeah,
said,
start with baby steps.
right,
They've been talking about uniformity
Mm-hmm.
for
20 years.
over 30
20,
years.
30 years.
This is not
New,
It's encouraging to hear the things that they're working on and there's, but
right,
like
it
I
is.
said,
But it's
the
not.
systems are very
20 years too
antiquated.
late.
Yeah, it's not an
Uh,
overnight.
Yeah, I initially came to your meeting that I saw publicized, I think it was maybe the one back in June, or when we were waiting, when the CPS director was supposed to go.
Oh,
And
yes,
I came to, because I was like, because I'm an educator in the Harrison County, community, and I came because I know all of the things that are happening with kids, and I see the fallout from it. So, it just so happened I was available today to come again, so I was just, really interested to see what had changed from then to now. So,
I do think that a lot of things have to be done at the agency level, because just like you saw with that law, every time the legislature does a law, I've been up there 2 sessions and I've learned a lot. There's unintended consequences every time. There's a wise man once said, there's not 2 sides to every story, there's 3. So you think it's black and white, it's not. So simple things like, and I agree with what you said, that coming out, that is abuse to me. If a parent brings a child into the world, that's abuse to begin with right there. So I do think the checkpoints, and I think you're very right on that, has to be done. I was sitting here thinking, and Senator Wiggins he's a brilliant guy, and I'm thinking about a lot of things, I'm listening, and what could you put into law? The problem is, again, every time you do one thing, then you end up creating harm another way, that unintended consequence. I say it over and over and over again. But the checkpoints at the very beginning, that's not law, that's something that can be done within agencies. I think I think you're right on that. I think it's good.
it's just being able to work with the agencies without they saying that this is not in our procedures or policies, or we can't communicate with the blue ribbon community. We've gotten that numerous times, we can't give you that information.
And there's a lot of, and a lot of that is confidentiality and stuff like that. I'm in banking, so I understand, that whole side about confidentiality. There's certain things, well, why can't I just say, we can't even say if a spouse came into that branch that day. There's rules that prevent that, but I also know that, there's a lot of people that don't, it was mentioned before about, don't want cheese moved. And, taking the number of years in education, my sister's a teacher at Gulfport High, my mom was an educator for 30 years, I taught school for a little while. There's a lot of people, right, that don't want to consolidate school districts. We've got way too many superintendents. When you look at it from the, Texas has less than we do. We're, I don't know, what, 1/15th the size of Texas? So which school district can you consolidate? And so you see a lot of that, you probably see that within agencies and stuff, but I do think the checkpoints, those things like that, I think that's a simple implication that we do right from the beginning. That is a good thing that with Senator Wiggins, I didn't realize his background. I knew he was an attorney. I didn't know until now what his background was. But I think between that, Joey Hood, who's the chairman of the committee I'm on, Judd A., they've got a good working relationship. So I think there's some momentum. You get both sides of the houses, the chairmans, then things tend to happen. The problem is a lot of times, if you don't get that, it's not gonna happen. So I think the immediate thing's gonna happen. I think the long range, I think the whole system has to be changed. But I do believe that like you said, the checkpoints, right from the very beginning, things have to be done, so.
Great, thank you. And you have my email if we can help in any way.
And what's funny too is my uncle, Johnny Morris, was the Chancery Court judge. Back in the day, it was Hancock, Harrison, and Stone. And I can remember, he didn't talk much about court, he never talked specifics. But the one thing I can always remember him saying was that the children should be with their mother, which is interesting. The families, the same that Bryce saying. My father was killed when my mom was 5 months old, and he was a captain of the Air Force. I never had a dad. So, but I can tell you that, I've got, my wife and I have 2 sons that, you love your dad, but being with that mother is so important, so nurturing and stuff. So You know, I do think that there's a lot to be said for that if you keep them in the families, but if you bring a baby into this world because you were on
Right.
drugs, that's already abuse, so.
Absolutely, that's what we all agree.
That was the,
The crux
that's,
of the whole thing, right here.
I think you have that, where you
Okay.
can see where that was changed. If you can go back and look at the previous statute
Statute.
and
Okay.
how it was amended. And that's kind of what actually enabled some of this to happen. So, okay, so if we don't have any more questions, our next meeting is, you have the 20th, which is a Thursday, I think the
Is
21st.
it? Did I make a mistake?
So if you could correct your, our next.
Hey, I'm on
meeting is
vacation.
actually the 21st.
Yeah.
Which is,
Yeah.
She's trying to get.
right before Thanksgiving, and then we will be taking a holiday break.
Right, in
after.
December, yeah, we don't meet in December, so thank you all for coming very much, appreciate it.
Thank you. Yes, sir.
Did you say,
Oh,
did
I
you,
thought-
we thought you had a question.
Okay, so do I have a motion to
I
adjourn?
make a motion to,
Okay, second, all in favor?
Aye.
Okay, thank you guys.
thank you, Sarah.
Jean, will you send out the ruling that we received from Lynn Fitch's office?
Yeah.
Because some people haven't seen that apparently.
Okay, the ruling that Judge, that